This next section of our presentation focuses on the mediation option that is available through the Wisconsin Special Education Mediation System. I first want to draw your attention to some of the important rules and regulations and statutes that underpin our system. We've passed out for you a training manual, the effective participation in the special education mediation process. This will have copies of most of these rules in them. In Appendix A is the IDEA law, Section 615, and then Appendix B has the IDEA regulations, 300.506. Appendix C has our Wisconsin statutes, and then also you have handouts on 802.12, which really includes definitions of dispute resolution in the state and admissibility standards. And then also 904.085 has really a good description of the confidentiality protections for mediators, really that's used in all types of mediation in Wisconsin. But I think these are important to be aware that are available, and then also if you have time to actually go in and read them. Mediation, as you saw on the diagram that we originally started with the arrows, mediation was the next arrow after the facilitated IEP option. Mediation is the early conflict resolution option that's required by federal and state law to be available to schools and parents, and it's been available in Wisconsin since 1997. A trained neutral person, called a mediator, from our roster facilitates discussion and helps parties reach their own agreement. This is a faster process than other forms that were in dark green on the diagram, which 60 days for an IDEA complaint and 45 days for a due process hearing. Mediation must actually be scheduled within 21 days after the mediator is appointed. We're going to talk a little bit about the parties to mediation, and also I want to say that the process is free. Mediation does not have a time limit like facilitated IEPs do. Mediation often takes usually part of a whole day. The average for us is 4.5 hours, and some have taken longer, and some have actually had multiple sessions. We're going to talk a little bit later about confidentiality. Discussions during mediation must remain confidential within the limits of state law, and I've already referred to those laws. No records are kept or shared by the mediator or participants. The mediator may be called to testify about the mediation, or may not be called to testify about the mediation. And information may not be provided that a party declined to participate in mediation. I should say that a question has come up regarding when attorneys participate in mediation, and they are able to keep records, but it's under attorney-client privilege. If a mediation agreement is reached, the Stakeholders Council agreed way back when we first set up the system that only the two parties would get a copy of the agreement. So just the parents and the school get a copy of the agreement. The mediator does not, the system does not, and the Department of Public Instruction does not get a copy of the agreement. The Stakeholders Council also agreed that the names of the parents in the school district requesting and participating in mediation would also be confidential and not shared beyond the Wisconsin Special Ed Mediation System intake coordinator. So Nissan and I don't know the names of the coordinator, of the participants that are participating, and we don't share that information with the Wisconsin Department of Public Instruction. So it really does remain with, very confidential. The only data that is shared externally are the aggregate number of requests received, and you will have a copy of that in your packet, the number of mediations that have been declined, and the number of requests that had full or partial or no agreements reached. It's free to participate in mediation, as I said, and I think, to me, perhaps, and I think Nissan and I both feel this way, perhaps the most significant impact of mediation is the establishment of a collaborative partnership that not only helps in resolving the present dispute, but also provides parents and schools with a framework to resolve future disputes. Here are some of the other reasons to consider using mediation. And you can just read this. Really, it's to facilitate the early resolution of disputes, decrease the cost of resolving disputes, save time preparing for and participating in due process, and you can read the rest of that slide. There's, there's a number of really good reasons to mediate. When to request mediation? Truly, mediation is best used early in the process, when there's help that's needed to resolve a specific dispute, when impasse has been reached, and impasse really kind of means discussion has hit a brick wall, when there's no movement going forward, or when there's a strong history of dispute between parents and school. Federal and state law provides that mediation can be used for issues dealing with evaluation, disability identification, placement, IEP issues, and the provision of FAPE, free appropriate public education. So pretty much this is very, very broad. A referral to special education, though, must have been made. The system cannot be used for general education students or issues related to 504 plans. And so really the student and the family must be in the special ed pipeline already, with the referral having been made. You can see on the screen the request form that we have available. This can be found in Appendix H of your manual. It also is available online on our mediation website. The request form is sent to the office. It can be mailed, faxed, emailed, whatever. It doesn't go to DPI. It goes right straight to our neutral intake center. And, I don't want to, I really can't emphasize enough the importance of our neutral intake center as being critical to the success of our system. There's no one outside of Jane Burns at Burns Mediation Services that knows who's submitting these requests. Not DPI, as I said before, not the mediation partners or the outreach coordinator. The request has to be in writing, so it does need to be on this form. And you can see that there's just a little space, really, in the middle of the form to give a brief description of the dispute. For example, they could just write transportation issues or IEP issues. Doesn't have to be a long, drawn-out explanation. I can remember when we first started the mediation system, we were getting 15-page attachments onto the request form, and part of this is because people were so used to making requests for due process hearings that they thought they had to give all the information possible. And really what's cool about this is they just have to put a very, very brief description, because once mediation starts, a variety of things can be discussed. It doesn't just have to be limited to what's on the form, whereas in due process, you can only discuss what's on the form. Wisconsin Special Ed Mediation System really encourages joint requests. So you can see at the bottom on the left side is a spot for the information about the district, and on the right side is the information about the parents and the student. A single request, so the process can really start with both signatures, or the process can start with just one signature. So either the district or the parent could also make the request by themselves. I would say that a single request takes longer to get through the system because Jane Burns has to follow up with the other party to get the second signature. There are timelines in our Wisconsin statutes that cover how long it has to take from when the request comes in to notify the other party, and then timeline for that party to agree or not agree to participate. The letters that go out to the school and the parent, as a follow-up, they're all in Appendix E. So you can actually go to Appendix E and see what the letters look like that go to the district and the parents following this request. Again, what is great about mediation is that every step of the process is voluntary. You only participate if you want to. You can stop anytime if you want to. So if a parent requests mediation and the school decides they don't want to participate, the mediation doesn't go forward, and vice versa. Jane Burns then screens the request for mediation to see if the case meets the legal requirements to be able to take the case, and then asks the parties pretty much the same questions that are asked that Nissan referred to when he was talking about the facilitated IEP process, plus some additional ones after that. And you will see, again, in Appendix D of the training manual is the actual intake form, so you can see what questions are going to be asked. The mediation has to be scheduled within 21 days after the mediator is appointed. Mediator selection is really an important part of the process, and we're going to talk about that, I think, in a minute, but I just am going to mention that on the request form, sometimes people actually write on there, there's not a space for it, but they can just write it in the middle there and actually say, you know, I'd like to have so-and-so for my mediator. But ultimately, both parties have to agree on the mediator. So, you know, one party might write, I want so-and-so for the mediator, and the other party sees that and says, well, just because they requested, now I don't want that one. But sometimes they do agree, and both parties have to agree on which mediator to use. If they don't, if there's, you know, some difficulty getting an agreement, Jane will suggest a mediator, and she really goes to a lot of trouble matching the mediator to the case, using their biographical information, their background, history of the type of cases that they've successfully mediated, input from the parties in terms of what they're looking for in a mediator, and information that she took from the intake and screening process. For example, whether they have special language or cultural preferences. This really experienced and thoughtful matching of mediators to cases is a big reason why our system is so successful. Some other states just have a list of mediators and they go down and just take the next person on the list. Because of this pretty great case matching system that we have, it really contributes to a high degree of success. The mediator is responsible for scheduling the actual mediation date with the parties. They both need to agree on the location that's convenient to them, really so that they can feel comfortable and safe. And I would say that mediations have been held in such locations as public libraries, community centers, banks, sometimes at the school, sometimes at an attorney's office. So it varies. Now, who can participate in mediation? Our state legislation provides that mediation participants include the parents or competent adult student when the student is over 18, and 2 school representatives. In our law, the school representatives were not defined any further than just that. So in some cases, this can include the school attorney as one of those representatives. Other people can participate, but the parties must agree on who those additional people could be. So keep in mind, 2 parents, 2 school representatives. Other people that might attend, you know, we've had relatives attend, neighbors, advocates, attorneys, and they would all have to be approved by the school folks, and school people might find other IEP team members, you know, and again, those people would have to be approved by the parents. You know, questions come up about the participation of attorneys, and truly, you know, if there's a concern about an attorney participating, always keep in mind that, you know, if the attorney isn't present right in the mediation, they're really going to be available as a consult on the side, probably in the background, by phone or whatever, and, you know, think that it's probably better, you know, if they are going to be around, to have them in the session so that they can hear the whole conversation. And our statistics show that whether attorneys participate or not, the results, the percentage of you know, mediation agreements is just about the same whether they're there or not. But Just, I think people get worried if there's an attorney there, and sometimes it's really good to have one there. Let's talk a little bit about the mediator's role. The mediator helps the parties decide who will participate in mediation. So that discussion about the parties, sometimes the mediator can be very helpful in terms of, identifying, who the parents want there, identifying who the school wants there, and helping them think that through. The mediator spends time to make sure that the parties understand what to expect from the mediation session. Their role is really to help facilitate and structure discussion between the parties during the mediation session. As we said earlier, our system trains mediators so that they have a working knowledge of special education laws, terminology that we use in special education, and about some of the current issues that are, swirling around in the current year. For example, open enrollment, school vouchers, Common Core standards, things like that. And any new laws that have passed. For example, the seclusion restraint law, when it passed, we did some training for the mediators on that so they understood, what that is. But I would say that it's important to know that it's working knowledge. Their role is not to serve as a decision maker like a judge or a due process hearing officer. They don't actually impose a decision, or can they interpret law during a mediation session. Their goal, rather, is to help the parties talk together, communicate, and reach an agreement about their issues. When a mediation session gets started, one of the first things that the mediator will do is they will have parties sign an agreement to mediate. You have a copy of the agreement to mediate in Appendix G in your training manual. These are the things that are, on that agreement. It just kind of says, who's that the parties are agreeing on the person that's going to be mediating the case. They understand that the mediator is not going to be able to provide legal advice. The mediator spends some time explaining what conflict of interest is, and will give some disclosure as to whether they've ever worked for a school or have ever, had, been a parent of a child with a disability or something. So that's disclosed at the front end. And the agreement to mediate outlines what the mediator's authority is, and then again lists when the time and place that's been selected for the mediator, the mediation, everyone agrees with. These are other contents of the agreement. And I want to say that one of them is how a mediation would be terminated. One would be, at the end, if there is an agreement reached. Another way would be if the mediator states that further efforts at mediation would not contribute to a resolution of the dispute. And, the mediator may find, 3/4 of the way through, halfway through the mediation session that, that they can't be helpful. Or by a declaration of a party or parties. So if during the mediation, one of the parties decides that this is totally not working for them, they can say, I would like to terminate the mediation. So in the agreement to mediate, this is clarified to the parties at the front end. So they understand that they could stop the process themselves. Again, this is a voluntary process. They're not chained to their chair, so they can stop the process if they feel it's not productive. And then they talk about the actual mediation sessions. The mediator spends some time explaining caucus, which are individual sessions where the mediator would meet with one or the other party in a confidential setting. And then they remind them about the confidentiality of the process and how the agreement happens. And they also talk a little bit about recording, and mediation sessions are not recorded during the mediation. So all of that is done, and I think, make sure to look at that agreement so that you understand what it says. But again, the mediator spends some time going through it. And I'm just going to, talk to you a little bit about the actual agreement that is the goal at the end of the mediation. If parties, as they go through their mediation session with the mediator, if they are able to reach an agreement, it is in writing. And again, our stakeholder group agreed that only the two parties would get the copy. So the parents get a copy and the school gets a copy. The mediation agreement there's not a specific form for this. So I want you to understand that anybody could write it up. So the parents could write up the agreement on the spot and everybody could sign it. The school could write up the agreement and everybody could sign it. They could have an attorney write it up and bring it back to the group and have everybody sign it. So there's a variety of ways that an agreement could actually get written up. Actually, the mediator can write it as well, but they have to be what they call a scrivener, meaning that the parties have to tell them what to write on the paper. So they're not allowed to actually write it up for the parties, because this kind of gets into what they call practicing law without a license. And I think the important thing about this agreement is that people tend to, the mediation agreement outlines what parties feel they will be able to do to resolve this situation. And people tend to follow the term of mediation agreements because they participated in developing them. So this stage of actually writing what they agreed on is really important. In mediation, the written agreement is legally binding, which means it's enforceable under Wisconsin contract law. I want to point out that the mediation system does not have responsibility for enforcement of the agreement. So, it's really important to potentially include in your mediation agreement what we want to call like a loop back provision. In other words, put in a provision into the agreement that says, if there's some confusion about how to implement the agreement, or if things aren't working out quite as well as the parties thought, that they would agree to go back to mediation, to loop back to mediation and continue working on it and maybe drafting a new agreement. Oftentimes, a mediation agreement, if there has been a due process pending or an IDEA complaint or an Office of Civil Rights complaint or some litigation, it would be important for the agreement to specify that those would be withdrawn. Being really specific in that agreement is so important. It's like, who's going to do what, by when are they going to do it, so that there's not a lot of question. And the other thing that's important to include in the agreement is how to share the information. So how to share it with the public, how to share it with the school board, how to share it in the IEP. It has to be pretty clear as to where is this agreement going to go. There are no guarantees that mediation will lead to agreement. Even in the process of mediation without agreement, just the sole thing of participating in mediation, it often helps parties identify issues or even reach a partial agreement on some of the issues. And this may help communication in the long-term relationship. So, even when you don't get an agreement, sometimes it's not, a total failure. We collect a lot of information related to our system. In Appendix F, you will find the questionnaire that we give to participants following a mediation. This is a mediator's responsibility to make sure that the parties get this form, and everybody that participated in the mediation would be able to to fill out a form, including advocates, attorneys, all whatever IEP or whatever school staff participated, whatever people participated for the family, students if they participated. So be sure, if you don't get a form and you are having a mediation, that you say, could I have my participant form? because it's important for you to share information about what your, about your experience with the mediation process. So here's, kind of our running statistics on the mediation system. The first bullet of all of these is the longitudinal data that we have from 2000 through 2012. So you can see that satisfaction with the mediation process as a whole is actually pretty high. Again, people that would said that they would use mediation again, 89%, that's really great. And people that said that they would use the same mediator again, it's high. Usually in the mediation just realm in general, anything that's 75% to 80% or 85% is really considered a high quality system. So these are great statistics. Other mediation data you can just see on here as we keep track of, whether we got agreements. There were agreements in 87.1 cases over this lengthy period of time. Again, very high. And the number of sessions per case, I said it varied from 1, sometimes 1.5. So as a whole, over this long period of time, it's usually been 1 day. And the average length of a mediation session, 4 hours, which doesn't seem like a lot, especially since some of them have gone a little bit longer. But I think that, the data speaks volumes of how successful the mediation component is for our system.